Good afternoon and welcome to another episode of Lunch and Learn. And today we will be discussing how and when a criminal court, could actually change the criminal proceedings to a maintenance inquiry. And we find that that happens quite often in maintenance situations where a person or a respondent is in default, and then it lands up in the criminal justice system, in the criminal process. And then at one stage, the magistrate or the court then converts this whole procedure of the criminal justice system, they convert that back into a maintenance inquiry. So the question that we will be addressing today is when and how does that happen? When can you actually convert a criminal trial into a maintenance inquiry? To have a brief overview of the discussions for today, it is dealt with in Section 41 of the Maintenance Court Act, where we will also have an explanation on when the court can actually convert the criminal maintenance matter for inquiry in the maintenance court, and then evaluation of some case laws. I'll be making references to a couple of case laws, and what would happen if the arrears, can the magistrate write off the arrear amount, and so forth. We will be dealing with that. And then Erin will be taking us through the whole procedure of the offences and the penalties that is governed by the Maintenance Act. So just for some logistics, if you have registered on our website, www.lunchandlearn.org.za, you would have received a link, and on that link would bring you to this webpage where you could watch the live stream, and you would also have the resource and templates tab where you can download all the documentation that we will be referring to during this webinar. We also post on that resource and tablets or tab, resource and templates tab, all the case law that we will be referring, some examples of documents that is discussed during this whole webinar. And yes, it is available for download on that tab as well. Just once again, welcome to all our online attendees. We have quite a number of people because we are streaming to our YouTube channel as well as our social media platforms. And we have quite a lot of people attending today. Thank you so much for attending, and we hope you find it insightful. Without further ado, I think we should just jump right into it and just have a recap. Remember now, we're talking about criminal conversions where the criminal maintenance matter will be converted to a maintenance inquiry. So just as a general recap on the remedies that you would have in the event that a respondent is in arrears, obviously you would have the warrant of execution, you would have the attachment of emoluments and the attachment of debts, and that is dealt with in terms of Section 27, 28, and 30 of the Maintenance Act. Other remedies that are also available, obviously sequestration, the claim for future maintenance, if the matter is being transferred to mediation as well, that would also be available. That is now if the respondent is in arrears. But we talking today, we will be discussing specifically with regards to the contempt of court, the criminal aspect of a respondent being in arrears. And that is what we will be addressing, because if a person is in arrears and the matter ends up in the criminal court or the criminal justice department or the system that deals with the criminal aspect of maintenance, the matter could be transferred back to the maintenance court in certain instances as a conversion in terms of Section 41. And that is what we will be dealing and discussing today. So just in general, just as a point of departure, what is quite important is to distinguish that there are two sides, two components of a respondent being in arrears. Number one would be that there would be some civil proceedings. Now, civil proceedings in terms of the Maintenance Act deals with the new application. It deals with the variation, upward or downward variation, increase or decrease of a maintenance order. The normal Section 6 inquiry, where you go to the maintenance officer's office and you enter into negotiations, those are all considered to be the civil proceeding aspect of maintenance. Obviously, if the matter is dealt with in terms of Section 10 in front of a maintenance magistrate, that's also considered to be a civil proceeding. Paternity disputes would also be considered to be criminal proceedings. And then the civil enforcements, like I mentioned, Section 27, 28, and 30, the emolument attachment order or the garnishee order, warrant of execution, and the attachment of debts. Those are considered to be, bear that in mind, that is considered to be the civil proceedings. Now we turn to the criminal side. The criminal proceedings would include where you lay a complaint for arrears of arrear maintenance. Now, remember, we could also deal with that with a civil procedure in terms of the garnishee order or the warrant of execution, but there is also a criminal aspect there too, and that is dealt with in the criminal court, and that is considered to be criminal proceedings. Once you lay a complaint of arrears, that is then the person or the respondent is in contempt of court because there is a valid maintenance order in effect and in place. And if the respondent, if they do not adhere to that, then it is considered to be contempt of court. And obviously, there's a criminal sanction thereon. I'll discuss that in a moment. The matter will be investigated by the maintenance officer. The maintenance officer has got the file. They've got the maintenance file, so they'll investigate the matter. They'll ask the maintenance investigator to assist to get all the documentation from the banks and so forth in order to build a case, a criminal case against the respondent for being in arrears with a maintenance. The matter then goes to the criminal court. So the matter is handed over, the file is then handed over to the prosecutor, the public prosecutor, because the public prosecutor is the person that institutes the criminal proceedings on behalf of the state, because it is a criminal offense for not paying maintenance. So the matter is then out of the hands of the maintenance officer, and it gets treated, or it's handled and addressed by the public prosecutor in a criminal court. A criminal trial will follow where evidence will be led, and the state needs to prove their case in front of a criminal magistrate. So the criminal magistrate would then give a judgment or a verdict and or a sentence if it was found to be willfully in default with a maintenance order. So they would hand down a judgment or a sentence, and that might be a fine, it might be a suspended sentence, it might actually also be jail time. But during this whole procedure, there is a provision in terms of Section 41 where the magistrate attending to the criminal aspect thereof, the criminal court proceedings, can convert the whole proceedings back to the maintenance court for a financial inquiry. And this is what we will be addressing today. Like I've mentioned, in terms of Section 31, it is a criminal offense. And the respondent could be found guilty of an offense and liable for conviction or a fine, imprisonment for a period of not exceeding 3 years. So a person could be sentenced to jail time if he does not pay maintenance. And then the provision of subsection 2, where it says it should not be, the lack of means should not be due to his own fault or his unwillingness to work or misconduct. So that is, in short, what Section 31 says pertaining to the criminality of a defaulting maintenance order. So conversions of a criminal trial happens. When does it happen? In terms of what section does it happen? It happens, it is conducted, or it is done in terms of Section 41 of the Maintenance Act, where it reads, and I'll quote on the Act specifically, because it's important that you understand the wording thereof. It says that if during the course of any proceedings in a maintenance or magistrate's court in respect of where a person is guilty of an offense in terms of Section 31, that is now if he is, when criminal proceedings has been instituted in terms of Section 31 because he did not pay maintenance, or the enforcement of any sentence, a suspended sentence that he might have. So if the court gives a suspended sentence and he is still in default and you want to go to court in order to have the suspended sentence converted into direct jail time, during this whole procedure, in any proceedings in the magistrate court, If there is good enough reason, if there is good cause shown that it is desirable to do so, the court then may, on its own accord or on the request of the public prosecutor, convert these proceedings into such an inquiry. That is a financial inquiry. That is dealt with in terms of Section 41. So when could it be done? The simple answer, if we look at the Act, says that during any proceedings in the magistrate court. Now, remember now, the maintenance court is also considered to be in the maintenance court. So during any proceedings, usually the criminal proceedings for being in arrears is not done through the maintenance court, but it is done through the normal magistrate court. So during any proceedings in a magistrate court, if there's a charge in terms of Section 31 of being in arrears, or the enforcement of a suspended sentence, then we address the when could it be used, the Section 41 conversion. Why is it done? If there is good cause shown, or it is desirable to do so. And we'll get that and we'll address that in the next couple of slides. Who can do that? Very important to note that the court may, on its own accord, so the court can decide on its own to convert this whole criminal proceedings into a financial maintenance inquiry. The court may do that, or it could be done on the request of the public prosecutor. Bear in mind that the attorneys cannot ask for that. I've seen it happen in a couple of cases where the attorney or the legal representative for other parties insists that the matter be converted. It has no bearing, and there's only the court on own accord or the public prosecutor dealing with the criminal aspect thereof that could convert the matter into or request the court to convert it into a maintenance inquiry. Not even the maintenance officer could come with a request that the matter be converted in terms of Section 41. So what are the defenses when it comes to conversions of criminal trials into maintenance inquiries? So when any form of defense unrelated to the ability to pay is raised, then it should be desirable, or it should be appropriate, that the proceedings then be turned into a maintenance inquiry. So those, if the respondent comes and he has any form of defense which is unrelated to the ability to pay, and that was dealt with in the Pieterse case in 1993. Also, when an accused, if they dispute paternity, and it was not done during a Section 6 or Section 10 maintenance inquiry, and it only comes up in the criminal trial, after an order, it might be a default order that has been granted. If the paternity is then raised, the onus is not on the state at that stage to prove the paternity. The correct procedure then there would be to convert the whole proceedings into an inquiry, to hold a separate inquiry as to the paternity of the matter. Very, very, very important. Please note that the conversion of a criminal trial into a maintenance inquiry does not mean that it is a withdrawal, but it is merely a conversion, so that the court will indicate that on their records, it is not that the case has been withdrawn and the case has been thrown out of court. It is just a simple procedure that an inquiry needs to be done following a criminal charge being laid against the respondent. So what happens in practice is that most often that the criminal court deals with that might not even be in the same building. It could be in the other department or other floor of the court building. And the criminal court would deal with that because there's a prosecutor involved as well, as part of the normal criminal justice system. Now, if the magistrate converts that, usually what happens in practice, wrongly so, is that they transfer the matter back to the maintenance court. So that means that the matter needs to be dealt with an additional magistrate, another magistrate dealing with maintenance matters. And that might seem problematic because, in effect, that would mean that the case would be postponed once again. And the complainant or the applicant in this matter would be left without any recourse at that stage. Now, in September versus September, that is a judgment that was handed down in February in 2012. The learned judge actually said that it provides that Section 41 conversions should and could continue before the same magistrate, the same prosecutor, and the same attorney. And it's not necessary that it needs to be transferred back to the maintenance court. And the reason for that is that in terms of Section 4 of the Maintenance Act, any prosecutor is deemed to be a maintenance officer. And that was the fallback, and that was the excuse that most of the prosecutors used to say, but you know what, we cannot attend to the matter because we are not trained maintenance officers. But in terms of Section 4, they are deemed to be maintenance officers, and they are allowed to attend to that matter. So it could happen, and I've seen it happen in a number of instances where the matter is then conducted after the criminal proceedings. When it's converted, it is dealt with the same court, with the same magistrate, the presiding officer, and the maintenance or the prosecutors. They're deemed to be the maintenance officer, and then they could be the inquiry could be done. A magistrate trying a person on a charge under Section 31 is not empowered to alter the amount of maintenance payable. And that is the biggest concern that most of these applicants have. They think that if they go to criminal court, that the matter would be attended to, and that the arrear maintenance would be written off, or that they might actually get less. The maintenance or the presiding officer might change the amounts. It is very clear that the criminal matter, the criminal court, does not have the power to alter or to change the maintenance amounts. This could only be done in terms of Section 16, and that is the maintenance court that could do that. However, if a maintenance magistrate feels that the amount of the maintenance payable is inappropriate, it might be too little, or it might be too much, the correct procedure there would be to convert the matter into a financial inquiry in terms of Section 41. So there is a fallback, and there is some recourse if the maintenance or the magistrate dealing with a criminal matter feels that the amount might be inappropriate, that in such instances, the matter could be converted into a normal financial inquiry. Now, there are three distinct situations where conversions happen. And those, and I'll be dealing with all three aspects. Number one is cases in which the liability of the accused to maintain the dependent named in the maintenance order is in question. That is the one case. The other one is in cases where the amount that needs to be paid is in dispute, or in cases where the ability of the accused to pay is in dispute. So let's discuss in short each and every one of these cases. And the first one that we want to discuss, and there needs to be a distinction between these three incidences. The first one that we will be discussing is cases where the liability of the accused, remember now he's an accused because it is in criminal trial or in criminal court. So in cases where the liability, his obligation to pay maintenance of the person named in the maintenance order is in question. So he disputes that. Now, if one looks at that, when would that happen? Obviously, the only reason why a court would then entertain the conversion into the criminal trial into a maintenance inquiry would happen if there is a real triable issue. So there should be a real issue, and there should be sufficient particulars that popped up to show that there are grounds on which the accused liability is questioned. It should not be a frivolous matter. It should not be used as a delaying tactic. The maintenance or the magistrates, the presiding officer should be cautious about that. And obviously the public prosecutor would also have some insight into that if that might be a frivolous matter being brought up as a defense from the respondent or then the accused. And obviously, lastly, the the reason should have some substance before it could be converted into a maintenance inquiry. The second one that I would like to discuss is cases in which the amount that the accused needs to pay is an issue. So there is a maintenance order, but the amount that he needs to pay is in question. It might be the wrong amount. It might be that he was not present when the order was made, that it was a default order, that the amount was wrong, or any of those. There are also about 3 crystallized instances where this could happen. And that is, number one, it is the deterioration of the father's financial circumstances and his ability to contribute. So if his circumstances change that he could not afford or pay the amount of maintenance ordered in the maintenance order, then that would be a reason, or that could be one of the grounds that the magistrate might consider in order to convert the proceedings into a maintenance inquiry. The other one would be an improvement. Remember now, the one is the deterioration. So the father's financial circumstances have changed. He cannot afford that. On the other side is also true, where there's an improvement of the mother's financial circumstances and her ability to contribute. Remember, in terms of Section 15, it is pro rata contributions of both parents. So if the mother's circumstances have changed to such an extent that she earns more, or she received a promotion and so forth, then that would warrant the investigation and changing of the criminal trial into a financial inquiry, because the amount that needs to be paid could be in dispute. And the last one, we don't see that often, is that when there is a relevant change in the dependent's child's own financial circumstances. Now, that is basically a contradiction in terms, because they are still a dependent child, but the child might receive a bursary from the state, or they might have a part-time work. And then the situation and the needs of the child might change. And that would also warrant the grounds for a conversion into a maintenance inquiry. The last one that needs to be addressed is cases in which the ability of the accused to pay is an issue. That is now to determine whether the accused has sufficient means to comply with a maintenance order. And that would mean that there needs to be an in-depth inquiry done to see what is his income, what is his expenses, and whether he actually has sufficient means to comply with that. Because it is not expected of anyone to comply with a court order if it's really not in your position, or if you are not in a position to pay that. If that is way beyond your means, it is not expected for you to pay that. And the right recourse would be to address that by converting the criminal trial into a maintenance inquiry. Another factor that also needs to be considered is to consider making a new order in substitution for the existing maintenance order on the grounds of changed circumstances. And that basically means that if there are good cause shown for that the maintenance order could be varied, either upward or downward variation, then those circumstances needs to be taken into account by the magistrate, the criminal magistrate, in order to consider and to give thought of changing the criminal proceedings into a maintenance inquiry. Now, a question that a lot of people asked, and I addressed it briefly, is that can a maintenance or a magistrate dealing with a criminal matter write off the arrear amount? And during a criminal trial, a magistrate is not entitled to write off any arrears or to vary the order. This is strictly done in terms of Section 16 of the Act, and that is the maintenance magistrate that deals with that. Before the arrears can be written off or changed or varied, the criminal trial must then be converted into a financial inquiry, and the burden of proof is then quite different than the criminal proceedings. In criminal proceedings, you have the burden of proof, which is beyond a reasonable doubt, and the onus in the burden of proof in criminal matters, or civil matters rather, is on the balance of probabilities. So the onus then of proving the amount that is in arrears rests on the state. So the state needs to prove that by the public prosecutor, that needs to probably get the information from the maintenance officer, and the maintenance officer might employ or ask the maintenance investigator to assist with regards to that. But the onus of proving the arrear maintenance, the amount that is in arrears, needs to be proven by the public prosecutor, obviously by the state. So if good reasons for conversion exist, then it could be changed. So examples of that could be that in the view of the accused income, means, and his duties towards all of his other dependents, the maintenance payments that he needs to pay in terms of the court order might be too high. That could be a good reason for conversion. Or he could raise the fact that his common law duty of support or to maintain has ceased. The accused could at any stage, if, say, for instance, the child has turned 21 or they become self-sufficient, then, and proceedings in terms of the criminal act, the contempt of court has been instituted, then he could raise the fact that his common law duty to maintain is actually ceased because the child is self-sufficient. If during this whole stage it is shown that the accused's failure to pay was due to lack of means, which did not stem from his unwillingness to work or his own misconduct, then the correct procedure would be that there should be a conversion, but into a financial inquiry, rather than to continue with the criminal act or the criminal trial. Now, that's actually a contentious issue, because the respondent or the accused is brought before criminal trial because he is in arrears. So if there is found, and the magistrate then, after inquiry and after hearing the evidence, or it emerged from testimony during this whole proceedings, that he is not unwilling to pay, but he does not have the means. The father or the respondent does not have the means, and it was not due to his unwillingness to work or his own misconduct. Then the magistrate, listening to this and hearing the testimony, will have to convert this whole procedure, the criminal trial, into a maintenance inquiry, so that that the means and the income of both parties could be discussed and then be addressed in order to vary probably the maintenance order. The question of, can a court hold a summary inquiry into the means of a convicted person? Now, this is dealt with in terms of section 40, where it reads that a court granting an order against a convicted person. Now, a court granting an order against a convicted person, so that is a person that has already been convicted of being guilty, may, after they've been found guilty, may inquire in a summary manner inquire into the circumstances mentioned in section 3, which we will deal with later. And then the court may at that stage issue a warrant of execution against movable or immovable property, that the sheriff of the court could go to the house or the premises of the convicted person in order to judicially attach some of the furniture, be it furniture or a vehicle or even a house, in order to be sold by public auction, so that the arrear amount could be paid. Now, Section 42A merely empowers the court to do such an inquiry. So they're not obliged to do that. And very seldom we see in criminal courts that they actually deal with it in terms of Section 40, where they hold a summary inquiry and then the issue of a warrant of execution. And the legal practitioners out there, it's actually something that you might consider asking and bringing to the court's attention, that they do have the remedy in terms of section 42A, to conduct such a summary inquiry. But the courts are not willing and they're not obliged to do that. State versus Magagula in 2001 mentioned it quite clearly, that it is up to the court to decide if they want to do that or not. And they are not, it just empowers the court to do that. They are not obliged to do that. To end off on this portion thereof, with regards to a summary inquiry, when should it when should it be done? The Act says that before any order for the payment of arrears of maintenance is made, such a summary inquiry ought to be held whenever there is room for doubt that the convicted person has the assets from which the arrears or substantial part thereof could be recovered by execution in terms of section 41 or subsection 42. And whenever there is room for doubt that the convicted person has the surplus income from which payment of the arrears or part thereof could be made by installments could be sustained. So what does that in practical terms mean? It basically means that after a person has been convicted of being guilty of not paying maintenance in terms of section 41, the court is entitled to do a summary inquiry with regards to his financial means and to issue a warrant of execution if it is desirable to do so, and if he does have the means, if he has a car, if he has a house, if he does have furniture, in order to satisfy that court order. And that is available, this remedy is available in terms of section 40 of the Act. So what does the court need to take into consideration before they give such an instruction and to hold a summary inquiry? So there are a couple of things that the court would look at in terms of section 43. The court would look at the existing and the prospective means of the convicted person. Remember, now the person has already been convicted of being guilty of not paying maintenance. So the court would look at the existing and the prospective means of the convicted person. The court would also look at the financial needs and the obligations of the person that needs to be maintained, and also the conduct of the convicted person in as far as much it may be relevant concerning his failure to pay. If a person is willfully not paying and they know that they should pay and they do have the means, the court would look at that conduct as well. And then the last one is any other circumstances which the court might feel that they need to take into consideration. Now, there are a number of case law dealing with the conversions, and because we are a little bit pressed for time, I'll put in the resource and templates folder. I'll put in a summary of all the cases dealing specifically with the conversions, because we see that it happens quite often in maintenance courts, where the matter is where the respondent goes to the maintenance court and then they apply for civil attachments, and combined with that, they also lay the criminal charge of not paying maintenance, and then subsequently the matter is being transferred to the criminal court, and then upon investigation, because it runs simultaneously. So you would have the criminal enforcement, the garnishee order, and the warrant of execution on the one side, and you would have the criminal aspect on the other side. But at one stage, there is a possibility that the criminal proceedings would be converted into a maintenance inquiry, and one needs to look at the case law regarding that in order to get a full understanding, a better understanding of, what is a good reason, when can the courts do that and when can the courts not do that. But for practical purposes, just to get awareness out there, it is not necessary for us now to deal specifically with all the legalities of the case law, but for your ease of reference, I will have a copy thereof in the maintenance, in the defaults and not the defaults, in the resource and templates tab, where you can download those documents. Next up, what we will be discussing is now the Maintenance Act deals with a number of offences. Apart from not paying maintenance, where a person is in arrears and he's failing to pay maintenance because he lost his job and it was his own fault because he slept on the job or whatever the case might be. Or he just stopped paying maintenance and he does have the means to pay, then that might be a criminal act. So the Maintenance Act deals with a number of offences or penalties in certain circumstances, dealing with witnesses, dealing with hindering or obstructing the workings of the court or the maintenance investigator, the maintenance officer, and so forth. And we'll have Erin taking us through this portion of Section 31 right to the end, dealing specifically with offences and the penalties that are available in the Maintenance Act. Over to you, Erin.
We'll now be dealing with the different offences and penalties as found in the Maintenance Act. Specific focus is from Section 32 up to Section 39, deals with specific offences and the penalties imposed for those offences. So Section 31, as we have already discussed in previous webinars, deals with the offences relating to maintenance orders and reads as follows. Any person who fails to make any particular payment in accordance with a maintenance order shall be guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 3 years, or to such imprisonment without the option of a fine. So Section 31, as we know, is the criminal proceedings for failure to make timely maintenance payments. So a respondent can be held liable in terms of criminal law if he or she does not make maintenance payments in accordance with the Maintenance Act. And then the penalty for that would be either 3 years imprisonment or a fine, or 3 years imprisonment without the option of a fine. The next one is Section 32, which deals with offences relating to the examination of persons by a maintenance officer. The provision reads as follows. A person who is required to appear before a magistrate and who refuses or fails to furnish the information in question shall not be sentenced to imprisonment as contemplated in Section 189 of the Criminal Procedure Act, unless the magistrate is also of the opinion that the furnishing of such information is necessary for the administration of justice. So this is where someone appears before the maintenance officer who needs specific information. This person fails to provide that information. They will be held liable in terms of Section 189 of the Criminal Procedure Act only if the magistrate is of the opinion that that information was necessary for the administration of justice. Section 33 of the Maintenance Act deals with offences relating to witnesses. So Section 33(2) reads as follows. Any person who, after having been sworn or having affirmed as a witness, willfully gives false evidence before the maintenance court, knowing the evidence to be false or not knowing or believing it to be true, shall be guilty of an offence and liable on conviction to the penalties which in law may be imposed for perjury. So this deals with witnesses. So being sworn or having affirmed as a witness, so you have taken the oath. So if you have taken the oath or affirmation, it means that you have declared to tell the truth, only the truth before the court, failing which you will be held liable for perjury. This means you lied to the court. So you withheld information or you gave false information. Section 33 deals with the fact that a witness gave false information, not unintentionally. So they knew the information to be false. They willfully gave the false information. They can be held liable for the penalties imposed for perjury. So this is not the situation where you believed something to be true, but it turned out to be false. This is the situation where a witness intentionally gave false information. At all times when giving the information, they knew it to be false. Section 34 deals with offences relating to false information. So Section 33 dealt with false evidence. Section 34 deals with false information, and this section reads, making a statement and willfully and falsely state anything which is not true shall be guilty of an offence and liable on conviction to the penalties which in law may be imposed for perjury. So just to go back, Section 33 deals with a witness who has sworn either the oath or affirmation that they will tell the truth, but then they give false evidence before the maintenance court. Section 34 deals with the false information. So making a statement, willfully and falsely stating anything which is not true. That person will also be guilty of an offense for perjury. Any person who is requested by a maintenance investigator or a maintenance officer to furnish information and who willfully furnishes information which he or she knows to be false or does not know or believe to be true shall be guilty of an offense and liable on conviction to the penalties which may in law be imposed for perjury. So as I've explained in terms of Section 33 with the evidence, if you as a witness make a false statement, knowing it to be false, so at all times when you were giving the statement before the maintenance court, you knew that the information you were giving is false. You did not believe it to be true. You will be liable for the penalties imposed for perjury. You have taken an oath or an affirmation in court stating you will tell only the truth before the court, but now you have given false information which is lying to the court. You will be held liable for penalties in terms of perjury. So Section 33 and 34 are very similar. Section 33 deals with the evidence given by a witness. Section 34 specifically deals with false information, so statements which are willfully and intentionally made, and then they were false. The witness did not even at any time believe the statement to be true. Any person who is requested by a maintenance investigator or a maintenance officer to furnish information in the performance of the maintenance investigators or maintenance officer's functions under this Act, and who willfully furnishes information which he or she knows to be false or does not know or believe to be true, shall be guilty of an offence and liable on conviction to the penalties which may in law be imposed for perjury. So if you give false information to the maintenance investigator or maintenance officer for them to perform their duties in terms of the Act, you gave them false information, you will be liable for the penalties imposed for perjury. You must at all times be honest. For example, if the maintenance officer asks you about your financial situation, be truthful. Do not give false statements saying you are unemployed when in fact you actually are employed. This will be seen as perjury in court because you are giving false statements. This is false evidence as well. You need to be truthful at all times. Section 35 deals with offences relating to maintenance inquiries. So Section 35 reads, any person who willfully interrupts the proceedings at a maintenance inquiry or who willfully hinders or obstructs the maintenance court in the performance of the maintenance court's functions at the inquiry shall be guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 1 year, or to both a fine and imprisonment. So if you willfully interrupt or obstruct a maintenance inquiry, you will be liable either to a fine or 1 year imprisonment, or to both a fine and imprisonment. So you cannot obstruct the functioning of the maintenance court when they're doing an inquiry. Do not interrupt the proceedings, do not obstruct the proceedings. You will be liable to a fine or to 1 year's imprisonment, or even both a fine and imprisonment. Section 36 deals with offences relating to the publication of information in respect of children. So we know that a child in the Children's Act is defined as any person under the age of 18 years. So this section reads that no person shall publish in any manner whatsoever the name or the address of any child who is or was involved in any proceedings at a maintenance inquiry, or the name of his or her school, or any other information which is likely to reveal the identity of that child. So any person under the age of 18 years involved in a maintenance matter. The child on behalf of whom maintenance is being claimed, in other words. You cannot publish any information relating to the name of the child, the home address of the child, or the school of the child, or any other information which is likely to reveal the identity of the child. Because any person who contravenes this section shall be guilty of an offence, liable on conviction to a fine or imprisonment not exceeding 2 years, or to both a fine and imprisonment. So if you, for example, post on Facebook the name of the child and their address, a child involved in a maintenance proceeding, if you post the name of the child, the school they go to, where they live, you will be liable of this Section 36 offence, and liable on conviction to a fine or imprisonment not exceeding 2 years, or both a fine and imprisonment, because you have now revealed the identity of the child in terms of the maintenance proceedings. This is not allowed. Section 37 deals with offences relating to disclosure. The section reads, any person who, except for the purposes of performing his or her functions under this Act, or when required to do so by any court or under any law, discloses to any other person any information acquired by that person in the performance of that person's functions under this Act, shall be guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 12 months, or to both such fine and such imprisonment. So you cannot disclose any information acquired by the person, such as a maintenance investigator or maintenance officer, while they were performing their functions. Otherwise, you will be liable to a fine or imprisonment not exceeding 12 months. Section 38 deals with offences relating to certain notices. It reads, any person who A, without sufficient cause, refuses or fails to make any payment in accordance with a notice under Section 16(3)(a), 29(1), or 31, or B, refuses or fails to give notice to a maintenance officer as required by Section 16(3)(b) or 29(2), shall be guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 2 years. The last one is Section 39, which deals with offences relating to notice of change of address. So this section reads, any person who refuses or fails to give notice of any change of his or her place of residence or employment as required by Section 16(4) shall be guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 1 year. So if you refuse to give the maintenance officer, for example, your new address or your new address of employment or residential address, you are guilty of an offence. You need to notify your change of address. Section 39A deals with offences relating to maintenance investigators. So the section reads, any person who willfully, hinders, or obstructs a maintenance investigator in the exercise of his or her powers or the performance of his or her duties shall be guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 1 year. So if you obstruct or hinder the duties of the maintenance investigator, you are liable to a fine or imprisonment not exceeding 1 year. It is a Section 39A offence to willfully obstruct the maintenance investigator in exercising his or her duties. And so that brings us to the end of the offences found in the Maintenance Act. Section 31 up to Section 39 all specifically deal with the different offences that you can be held liable for and the penalties that are imposed for those offences in terms of the Maintenance Act. Thank you.
Thank you for that, Aaron. Yes, important just to note, in terms of Section 38 and 39, the offences dealing with specifically those portions pertains to garnishee orders, emolument attachment orders, where the employer does not give information through, or they do not make payments, or they do not give notice to court if the respondent left the employment. Those are the sections that has criminal effect if the employer does not do that. So why is it important for us to know all these, for you as the complainants or the respondents even, to know what to look out for? There are certain offences and there are certain penalties that could be imposed in terms of the Maintenance Act. Does it happen in practice? No, not that often, especially when there is no cooperation from the side of the respondent. But those remedies are surely available. And if you know about these remedies, you can actually ask and request the maintenance officer to investigate and to bring criminal charges for a respondent refusing or giving false information and so forth. But the onus is upon you as the complainant or as the applicant to bring that to the attention of the maintenance officer. So if the respondent does have a full-time work, but he lies and he says, but you know what, he does not earn an income in order to evade his maintenance responsibilities, the onus is upon you as the applicant or the complainant to bring that to the attention of the maintenance officer, and then the maintenance officer then could investigate the matter and actually bring criminal charges to court for perjury and so forth. That is basically the reason why we brought in the penalties and the offences, so that you are aware of your rights, what you might have in terms of the Maintenance Act when it comes to offences. That is basically our lunch and learn for today. Thank you for joining us. We hope that you found it insightful and had some insight on the workings of how the proceedings in terms of the criminal justice system can actually be converted to a maintenance inquiry if there is sufficient cause. Thank you so much for all the people joining us online and watching us from our website as well as our social media platforms. My name is Eugene Opperman. I'm a family law practitioner specializing mostly in maintenance matters, matters dealing with the rights of children as well as domestic violence. If you have any inquiries or if you have any feedback, please drop us a line on info@lunchandlearn.org.za, and we would have one of the attorneys at our offices address your inquiry in order just to give you some more clarification if anything that we have said during this course of this webinar is not clearly understood, or if you might have a question pertaining to your matter as well. We will be able to assist you with regards to that. We hope to see you on next week for our normal run of Lunch and Learn, and we hope that you have a good afternoon further. Thank you so much.